Well, thank you all for being here. It is a beautiful day, and I know you could be outside doing yard work or running errands, but you chose to be here with us, and we wanted to start off by thanking you for that. This is an important topic we're talking about today, estate and legacy planning. Last year, Pilgrim Church came to us with an idea to do a speaker series, and so it was called Should I Stay or Should I Go? And it was all about the different factors that go into making a decision if you want to age in place or move to a senior community. And so we're really excited this year to be doing our second speaker series with Pilgrim Church. And this one's entitled Planting Seeds to Successful Aging. And we are going to be diving into equally important topics. If you look inside your folders, the blue folders, you will see a flyer. That's the flyer for this series. So today we kick off with estate and legacy planning. You won't want to miss next week. We're going to dive a little deeper into the Should I Stay or Should I Go series by giving definitive numbers, some planning tools, and some resources that we thought you might want, when considering housing options, because housing, let's just keep it real, is one of the most expensive things that you are going to be paid for. The third one is going to be navigating the healthcare system. And anyone who's ever had to navigate the healthcare system knows it can be complicated. And knowing what to do and how to get around it is vital. And the final one is financial planning. And so that'll be our last speaker talk. If you haven't been living under a rock, you know that there's a lot of uncertainty and people are really worried about what's going to happen to Social Security, what's going on with my retirement, should I do something with my assets? So bring all your questions to that one. After the speakers talk, you'll be given time to ask questions, or even during. Samantha said that during the talk you can ask questions. Samantha's just going to repeat the questions so that if folks want to watch this video later, they can. We will be recording this, but you're not going to be on video, just will be on video. Unless you want to be on video, then you can come on up. So thank you again for being here. We hope that you sign up for all of the series in this 4-week talk. We just ask that you RSVP so that we have enough handouts. Without further ado, I just want to introduce Samantha Gentel from Generations Law Group. She is an expert at elder law, also estate planning, mass health, long-term care, Medicaid. It goes under many names. It's a long one. Conservatorships, guardianships, and trusts. The way I met Samantha was that I was working with someone who was a solo ager. For any of you who don't know what a solo ager is, it's somebody who basically is aging by themselves. They may not have a spouse or children. Maybe they're a widow or never got married, but it has its own challenges because you don't always have somebody to name as your healthcare proxy, your power of attorney. And so one of the things that I found wonderful about Samantha is that not only is she a great lawyer, but she can act on behalf of her clients, which not all lawyers will or can do. So that was something really special. So I just wanted to thank her for being here today and pass this over to Samantha to talk about estate and legacy planning.
Hi, I'm attorney Samantha Gentel with Generations Law Group. We have offices in Sudbury, Acton, and Andover. I'm based in the Sudbury office, but I live in Natick, so it was a really quick drive over here. I come through Sherborn all the time. At our elder law firm, we specialize in estate planning. I'm the director of the long-term care department. Within that department, I'm in charge of estate planning, long-term care planning, mass health asset protection. I handle mass health applications for home care, nursing home care, and PACE. In addition to that, we handle guardianships and conservatorships, trust administration, some special needs planning, probate, and we also have an in-house attorney that handles estate tax returns. Some things that make our firm unique are the attorney fiduciary program, which you just mentioned, where we can help solo agers if they've maybe delayed doing their estate plan because they don't have anybody to name. We can serve as power of attorney, healthcare agent, personal representative and trustee for those clients. We really take a team approach. We bring in a financial planner, we bring in a geriatric care manager or aging life care advocate. We really make a team approach to helping you age where you want to age. And another unique program we have is our Aging Pathfinder program. That's something I developed within the long-term care department, where you can hire us in an advisory role to help you avoid pitfalls and just guide you as you age and navigate certain systems. We also have our client care program, which allows us to keep in touch with our clients on an annual basis. You can get invited to special events that are just for our client care members. We're really trying to create a family and community of our clients and not just be your average stuffy law firm. So I'm here today to talk about essential estate planning for aging well. As a reminder, this should be taken as general information only. Should not be taken as official legal advice. If you need legal advice, please seek out the help of an elder law attorney. So when you're thinking about an estate plan, it's not just about, avoiding taxes and stuff like that. It's about planning for your legacy, thinking ahead about family harmony, and all of those things that you want to think about. What is in your estate? So a lot of people say, "Oh, I'm not rich. I don't have an estate." If you have a house, if you have a bank account, if you have a car, you have an estate. So you need to plan for what's going to happen to those assets. Other things included in your estate are life insurance and personal property. So your tangible items, jewelry, artwork, etc., and pets. There are things called pet trusts where you can actually set aside funds for a beloved pet to make sure they're still cared for after you pass. And again, I'm happy to take questions as we go because I think it helps formulate the conversation. So some goals of estate planning are gifting, and gifting can be very tricky, especially as you age. If you're potentially in need of mass health to pay for your care in the future, you need to be very careful about gifting. You want to care for yourself and make sure that you have the funds and the ability to make sure you're cared for. Probate, you want to pass along values and ideals and also protect assets from creditors. So here's some questions to consider. Has your estate plan been reviewed in the last couple years? Do you have any jointly titled assets? Do you have, who are your beneficiaries going to be? Do you have a disabled beneficiary? Because you may want to set up a separate supplemental needs trust for them. Are your beneficiaries minors? So are they under 18 or are they in their early 20s? And are they going to be responsible with their inheritance? Because there's a ways you can plan for that too. And then also, if you yourself become disabled, what are the plans for that as well? And thinking ahead and making sure your wishes are followed. So some key definitions. Probate. So a will is a set of instructions to the probate court for what to do with your probate property. Probate property is property owned individually in your own name. So if you pass away and you have, let's say, a house in your name alone or a financial account with no joint owner and no beneficiaries, it will have to pass through the public process of probate before it can be inherited. There's nothing wrong with probate, but your assets become public record. It can be expensive in legal fees, and it can cause a delay in inheritance. So if you have a will or if you don't have a will, your assets will have to go through probate. I'll go through later, I have slides on how to avoid probate. But that's a common misconception. Some people think if they have a will, they don't have to go through probate. But like I said, a will is a set of instructions to the probate court. So the ways to avoid probate is having joint owners, beneficiaries, or property in a trust. And then another definition about taxes, there can be estate tax, so if you pass away in Massachusetts, now it's up to $2 million, so if you pass away with over $2 million, your estate may need to pay some estate tax. And if you're as a married couple, you can do some estate planning that can reduce estate tax and then allow your beneficiaries to inherit more money from you. There's gift taxes, so if you are gifting, right now it's up to, I believe, $19,000. If you're gifting more than $19,000 a year to an individual, then you will need to file a gift tax return with your taxes, and then that money gets added back into your estate after you pass away. And there is no inheritance tax in Massachusetts. So the essential estate planning, so documents that are very important to have: durable power of attorney, healthcare proxy. I want clients to have those before they have anything else, because those documents are used while you're alive. We've got living will, HIPAA, wills, trusts. Any questions so far? Yes?
Can I ask a question? I know you mentioned that you can gift up to $19,000 a year and not be taxed, but what about who you're giving it to? Do they get taxed on that money?
They don't, but the question was, when you're gifting the $19,000 a year, does the person receiving the gift get taxed? The answer is no. However, again, gifting, as far as tax purposes, that can be okay, but it's not okay if you need Mass Health in the future to pay for nursing home level care. There's a 5-year look back period for gifting for Mass Health, and Mass Health looks at all transactions of $1,000 or more. And if any of those transactions can be seen as a gift, that can cause a delay in eligibility and Mass Health coverage. So a very common mistake I see all the time is my accountant told me that I could gift $19,000 a year. Yes, that's true for tax purposes. That's not okay for Mass Health purposes. So that's a common issue I see all the time. So thank you for the question.
I have 2 questions.
Yeah.
Is, if the person you're gifting to is out of state,
Uh-huh.
does the law apply from the state that it's gifted from?
I think that depends, but I'm only licensed in Massachusetts, so I can't answer any other questions about other states. The question was, will they have to pay taxes if you're gifting to someone out of state? And I don't know the answer to that
And I
question.
just forgot my second question.
Okay,
sorry.
well, if you think of your second question, I'm happy to take it. Oh, yes?
Could you talk about immediate power of attorney versus a non-immediate?
I was just about to talk about that. Yes?
Could I ask you to repeat what you said about the 2 things that you wanted us to be sure we had? One was a durable power of attorney, and I didn't hear the other.
Healthcare proxy,
Okay,
and
thank
I'm
you.
gonna talk about both of those
Okay,
documents
thank
right
you.
now. Yes?
As you're talking about a gift, though, you're making a distinction between a gift and something that you pass on in the will, is that correct?
Yeah, so gifting is like for when you're alive,
Okay,
yes.
thanks.
All right, so durable power of attorney. Durable power of attorney names someone to make financial decisions for you if you can no longer make them for yourself. There are 2 main kinds of powers of attorney. One is effective immediately, the other is springing, which means it springs into action when activated by a doctor. So that means the document cannot be used until a doctor has said, this person is no longer able to make financial decisions for themselves any longer, and now the document's activated. I tend to recommend the one that's effective immediately. One, because trying to get a doctor to activate a power of attorney can sometimes take a very long time, and the loved ones that are trying to help you may lose out on protecting some of your assets because maybe you're private paying at a facility much longer than you need to because we could have protected some of your money. The other thing is, there are plenty of situations while you're alive, you're fully capable of making your own decisions, but you just need some help. Maybe you're tired, maybe you're in rehab and you can't go traveling around to all the banks and stuff like that. So having one effective immediately means that you can allow your loved ones to help you now, as opposed to waiting until you've lost the ability to make decisions. And so I find it very helpful, but of course, you need to name people that you trust, in any document, someone that's not gonna take advantage of you. You wanna have someone that's a trusted individual that you've known for a long time, that's gonna make financially responsible decisions, and is not gonna take advantage of you. Just to finish what I was saying, with a durable power of attorney, the person you name can interact with your bank accounts, can transfer money around, can help you pay your bills, and can sign contracts on your behalf.
Wow.
Any questions on that before I move on to another document? Okay. So, healthcare proxy. A healthcare proxy names someone to make healthcare decisions for you if you can no longer make them for yourself. Unlike the power of attorney, a healthcare proxy must be activated by a doctor. It can also be deactivated, so, if someone is unconscious, well, they can't make decisions for themselves, but once they regain consciousness and regain capacity, then the healthcare proxy can also be deactivated. The order in which you name people in this document is a little bit more fluid. So if you have, let's say, a primary healthcare proxy and two alternates, if they call the first agent, there's a health emergency, they call the first agent, and that agent doesn't pick up the phone, then they're gonna call the next person, because everybody's name, phone number, address is supposed to go in this document. But then once the primary decision maker is available again, then they will be the primary decision maker. What's very important about healthcare proxies, a common mistake we see all the time, is let's say you've done your a really nice, strong estate plan with an elder law attorney, and then you forget to give the healthcare proxy out to anybody, because the attorney's told you, give copies to your treating physicians, have copies at your local hospital, have copies available if you need to go to the hospital. Some people forget to do that, and also in an emergency, you may not forget to grab paperwork. For me, for instance, most of my doctors are under the Partners MGH umbrella, and a lot of the doctors around here are. So once I give my doctor my healthcare proxy, then it will get scanned into their system and then saved in my patient gateway profile. So any medical institution under that umbrella would be able to see my healthcare proxy. Now, there are other hospitals in the area that use different systems, like I think Framingham, Metro, Union, whatever, I think uses a different system. So, again, it's a good idea to have copies. The big common mistake that we see a lot is that you're at the hospital, you forgot your healthcare proxy, and some well-intended healthcare professional says, oh, you don't have your healthcare proxy? Here, sign the free state form, then you're all set. Well-intended, they don't realize a lot of the time that they may be doing something that's detrimental to your estate plan, because if you sign a new healthcare proxy, it will revoke the one you did with your elder law attorney. So it's super important that once you've signed one healthcare proxy, have copies available. We have, through our client care program, any clients that do estate planning with us, they get enrolled in something called DocuBank, which is an online vault for your estate plan documents. And you get a card that comes in the mail that says My Emergency Medical Directives, and you can put food allergies on there, medical allergies and medical conditions on that card. But with that card, you keep it in your wallet with your health insurance cards, and with the card, your healthcare proxy and HIPAA can be accessed anytime, anywhere. So if you end up in a situation where you need your healthcare proxy and you don't have it, it can be accessed by any financial institution. Medical institution, not financial. You have a question?
Yeah, you made the comment that this one is easy to go in and out of, which I understand.
Mhm.
Getting back to the power of attorney for just a moment, let's say you're incapacitated with a TIA or something like that, and whoever you've designated ends up taking over power of attorney, how easy is it to revoke that?
So the question is, if you are in need of assistance and the power of attorney's taken over, but then you regain the ability to control, can you revoke it? So you don't need to revoke the power of attorney if it's effective immediately, it's just always effective. But the understanding is you're gonna be having a conversation with your power of attorney to say, thank you so much for your help, I'm good now, I don't need your help any longer, and then they should back off.
What if they don't?
Well, then, yes, you could go back to your attorney. If you've named someone that's being hostile, then, you know, definitely remove them as your power of attorney and do a new one. So the way to revoke a power of attorney is to go back to your attorney and draw up a new document and remove that person as your agent.
So you can do that on a voluntary basis?
Absolutely,
Right.
if you have capacity.
Right.
If, what happens sometimes, unfortunately, is, let's say, maybe there's the primary power of attorney and then there's alternates, and let's say the primary power of attorney is starting to act suspiciously, then, you know, your loved ones or maybe the alternates may need to go to court to help you. So the whole point of having a power of attorney in place is to avoid a conservatorship through the probate and family court. You can think of a conservatorship like a court-ordered power of attorney. A guardianship is like a court-ordered healthcare proxy. So having these documents in place should avoid the need to have court intervention in your life, which is the goal. But yeah, if a power of attorney is being questionable and they have proof of that, the alternates might want to go to court and say, this person's being irresponsible with our primary person's money, and we would like the power of attorney revoked and to become her conservator. But if you have capacity and you think that your power of attorney is being responsible, then immediately go back to your attorney and drop a new document.
If it's a medical condition, I guess what my question, where I was going with this is that, you know, oftentimes, let's say you designated a child, as you get older, oftentimes they want to be more caring than maybe you think they need to be. My point being that if you had some medical condition and it was starting to ease up, can the physician then basically, just like with the healthcare proxy, say, I think they're capable now of making decisions, and that would help in terms of the power of attorney?
Well, like I said, the physician does not need to be involved when it's a power of attorney that's effective immediately. If you had a springing power of attorney and the doctor activated it, then yes, theoretically, it could be deactivated too.
What was that term, spring?
Springing. But like I said, usually springing powers of attorney do cause some difficulty, but it's certainly a comfort level thing, because some people are like, no way, I wanna be in full control until I can't be anymore. So, you know, I understand the comfort.
So that's a very specific power of attorney than a springing one. Okay, that's interesting, thank you.
Yes, a few minutes ago, you mentioned a type of card that you can get, that you can keep in your wallet, that sort of connects you to all of the different aspects, you know, the power of attorney, the healthcare proxy and so forth. And what was the name of the card again?
DocuBank.
DocuBank.
It's an online vault for your estate plan documents, and that's something we offer to our client care members that do estate planning with us.
Thank you.
And I think someone over here was first.
I just wondered whether one took a picture of one's healthcare proxy, would that work?
The question is, if you take a picture of the healthcare proxy, would that work? I'd say it probably depends on the health institution. A healthcare if you're working with the free state form, that's just one page. I mean, photocopies are permissible, so I assume they may want a paper copy of it, but if you can email it to somebody in the facility and they can print it out, that should be okay. But a healthcare proxy from an elder law attorney is gonna be several pages, because it has way more protections in it than the free state form. But yeah, theoretically, yes, because they're supposed to accept photocopies. I think you were next.
Going back, if I could, for a minute to power of attorney,
Yes,
if my daughter's way out in California, if I make it a power of attorney, is that awkward in terms of the things they have to do?
the question was, is it an issue if you name a power of attorney that's out of state? And the answer is no. It's, if the pandemic taught us anything, almost everything can be done remotely. I have had a surprising number of clients who have kids that are in Alaska and Hawaii that are power of attorney for their parent in Massachusetts, and we did a whole mass health application together we were able to upload documents to our online portal, or once in a while, if an original signature is needed, like a wet signature versus like a DocuSign online, we just use FedEx, you know? So you should feel okay doing it. Yes, there might be a little bit of hiccups here and there, but overall, it shouldn't be a problem to name someone that's out of state.
Thank
It's
you.
not great to name someone who's out of the country. There can be issues with that, but at least if they're within the United States, it should be okay.
Thank you.
There was a question over here.
About the healthcare proxy, should you call your doctor's office and see if you can get a copy of what they have? Because I think I've signed probably other things, you know, at the emergency room. I mean, I don't know if,
Yeah, that's a very common issue. So the question is, should I call my doctor's office to see what healthcare proxy they have? So whatever healthcare proxy you signed last is the one that's in effect.
okay.
So yes, that's a great idea to call your doctor's office to see if they have it. And you may also want to call the hospital to see if they have it and see what the date is on both of them. And the one that you signed last is the one that stands. And it would be a good idea for you to hang on to that copy.
Are there things that a power of attorney cannot do?
Yes, I mean, so the power of attorney, durable powers of attorney can say so many different things, so it really varies. A durable power of attorney you get from an elder law attorney is gonna be very broad, because you wanna have free authority to move assets if there's an opportunity to protect them. But I see lots of documents all the time that are missing key authority, like you can't transfer assets to a spouse, or you can't transfer real estate, or you can gift, but you can only gift X dollars. And so sometimes when we've got a very limited power of attorney, we end up needing to go to court to get extra authority to be able to protect the asset. So it's a very good idea to be talking with an elder law attorney, rather than even sometimes just a straight estate planning attorney is not gonna have the same elder law knowledge in terms of future planning for mass health. And then, you know, getting free documents online, you kind of get what you pay for, because you may end up with thousands of dollars in attorney's fees to go to court because you didn't check a particular box.
So if they need funds or anything, they can't remortgage the house, sell the house?
They would,
That
yeah.
depends on what's in the.
It depends on what's on, yeah, but a durable power of attorney I would draft would allow that power of attorney to sell your home and mortgage and whatever they need to do to protect you.
Somebody you trust.
So the next documents are the living will and most. So, I kinda wish the living will slide was first, so I'm gonna go to that one. Okay, so a living will is a document that outlines your end of life wishes. In general terms, it usually says, you know, if it's my time to go, please let me go peacefully. I don't wanna be in a vegetative state, pull the plug, those sorts of things. What's important to know about a living will is it is not legally binding. It is a reference point to your healthcare agents for what your end of life wishes are. And we always suggest that you have the conversation with your loved ones to let them know what your wishes are. But if you find that conversation very difficult, we actually have a workbook on our website that you can download for free, or call us and ask for it to be mailed to you, and it's a workbook to go through all the questions with your loved ones. What is legally binding is the MOLST form. MOLST, Medical Order for Life-Sustaining Treatment. That is the new DNR, or Do Not Resuscitate, in Massachusetts. This is a document you fill out with your doctor, not with your attorney. And when you fill it, you would do this with your doctor if you're very advanced in age or have a terminal illness, or if you're moving into assisted living. That's a common time where the assisted living will ask that you get emulsed. The doctor's supposed to give it to you on pink paper, and it's supposed to go on your fridge. And if EMTs are called to your home, they're trained to look at the fridge to see if you have emulsed, and then they're legally bound to follow what it says. In terms of healthcare, the last document I'm talking about is the HIPAA authorization and release. You may have signed a HIPAA release at your doctor's office when you're filling out paperwork at the beginning. That HIPAA release is gonna be that for that specific office. A document you can receive from an elder law attorney is a global HIPAA document. Anybody you name on this document can use it at any healthcare institution and can have access to your medical information and can communicate with your doctors. They cannot make decisions. So this document is super helpful as you age. If one of your kids or a care manager or a friend is maybe starting to accompany you to appointments to be a second set of ears or help you with medication management, or you need them to follow up with a specialist for you, having them on this HIPAA document ensures that they can have free access to that information.
Yes.
Yep.
Anytime you go to a hospital for a procedure or something, you always sign a HIPAA document.
Mm-hmm.
Is that document valid for this purpose?
So that, again,
That's on file?
if you sign a HIPAA release at a medical institution, it's only gonna apply to that medical institution. It's not, this document could work anywhere.
Okay, but if
So-
that institution is part of a larger group, as you referenced before, then the entire group would have access to it?
I mean, I think it probably just depends on, I don't know if like I don't know. The answer is I don't know. I think it
Okay.
depends.
All right.
One thing I wanted to, before I move on to wills and trusts, I wanted to take a moment to talk about the importance of estate planning in the LGBTQ community. In this community, there are a lot of solo agers and a lot of couples that maybe never got married, but they've been together and been in committed loving relationships for 30, 40 years. Estate planning is important for everybody, but it is even more important for the LGBTQ community. The reason being is if you have created a family of friends, a chosen family, they don't automatically get to inherit from you. They don't automatically get to make decisions for you. So if there's no power of attorney in place and no healthcare proxy in place, they are not gonna have priority appointment in the court if you need to go to court to get a conservator or a guardian. So it's just an even higher level of importance to make sure that the LGBTQ community gets their estate plan documents in order. There's a growing issue of, going back in the closet as we age because we're concerned about discrimination from caregivers. If we've had issues with name changes, that's a kind of a scary time right now in the climate that we're in. And so making sure that proper names are referenced in your documents to avoid any sort of interference in your life is really important too. So Generations Law Group is a big ally for that community, and we're happy to help anybody that has questions about that. So now I'm going to talk about wills and trusts. So a will, like I said earlier, is a set of instructions to the probate court for what to do with your probate property. And probate property is property owned individually in your own name. So if your house is in your name alone, if you've got a checking account in your name alone, those, if you pass away, those will have to go through probate before they can be inherited. So the court needs to follow the instructions in your will to say where it should go. So when someone passes away, their personal representative that was named in the will will need to, sometimes you can do it on your own if it's a smaller estate, but usually you're gonna need at least some help from the attorney. Hire an attorney, a probate attorney, that can help you file the documents with the court, get appointed, and then also will help you understand how to manage those funds and where they need to go and what you need to do with them. And there will be reporting to the court at least a few times and doing an estate tax return, all those sorts of things. The ways to avoid probate are having joint owners on property, having beneficiaries named on accounts, or having property in a trust. And you can put real estate and financial accounts in a trust too. The two main different kinds of trusts are revocable and irrevocable. A revocable trust, the biggest benefit to it is it helps avoid probate. If you are in a married couple situation and your estate is worth over 2 million, then in addition to avoiding probate, you can do estate tax planning in your revocable trust as well, to help reduce estate tax. The way a trust works, so there's 3 roles. You've got grantor, that's the person that creates the trust, that can be you. Trustee, the person that manages the trust, that can also be you. And beneficiary, the person who benefits from the trust, that can be you as well. So you can hold all 3 roles in your trust when it gets started. Then you named alternates, so you're gonna name alternate trustees. So if you're no longer able to manage the trust on your own, there are trustees that can take over to help you manage it. And then there's beneficiaries, so if you pass away, then where does your trust property go? It goes to your alternate beneficiaries. So doing a revocable trust and putting your home in it doesn't really change how you manage your day-to-day affairs. It will still be associated with your own social security number, so it doesn't really change your taxes in any way. A few things to know when you put your home in a revocable trust. One is you have to let your homeowner's insurance company know that you've transferred your house into a trust. They'll want to see a copy of the deed and the trustee certificate. Those are 2 things that your attorney should produce for you. It shouldn't change your policy in any way, but they just need to know it's been changed. For a period of time, you may get 2 property tax bills in the mail. That does not mean you owe double property tax. I know this because it happened to me personally in Natick when I did my trust. I was getting a property tax bill in my husband's name as us as individuals, and then us as trustees. And then it just means that the town system hasn't caught up with the registry of deeds, but eventually it goes away and you don't have to worry about it, but you will not owe double property tax. And number 3, there's a very common scam that gets mailed out anytime you update your deed. It looks very official. It says, hey, you just updated your deed. If you want a copy of it, send us $80. So deeds are free online, and your attorney should have copies available for you and should be sending you copies. And we keep PDFs of all of our clients' documents for years and years and years and years, so we'll probably have it if you need it. Any questions about revocable trust before I move on to irrevocable trust?
Question?
Yes.
So if you're married, you would have your spouse as a trustee as well? typically?
Yeah, if you're married, the question was if you're married, would you have your spouse as trustee as well? Yes, typically yes. There's, depending on your situation, you can do a joint revocable trust and you can each be co-trustees of your trust. Sometimes it's beneficial to split the assets between the spouses and for tax purposes. Some attorneys prefer to do that, others just stick with the one trust. But even if you split the assets, you could still each be co-trustee
So
of the 2 trusts too.
does that mean you'd have 2 trusts, one for the spouse, one for the?
Yeah, you may, it's really a matter of preference on the attorney, how they prefer to do it and the potential estate tax implications. So you could end up splitting the house in half between the 2 trusts and splitting, if you have like an investment account, maybe putting half in one trust, half in the other trust. But you could still both be managing both trusts.
So what's the advantage over doing a revocable trust versus doing the joint owners and the beneficiaries?
So, what the question is, what's the benefit of doing the revocable trust rather than joint owners and or beneficiaries? So, we usually do a combination of both. So the issue with just leaving things as joint owners is eventually that asset will become a probate asset after the first spouse dies. So then all those assets will end up going through probate. The other benefit is, again, if you have an estate worth over 2 million, then you miss out on the estate tax planning benefits of the revocable trust. But we sometimes I'll do a lot of times a combination of trust assets and beneficiaries. So for instance, I'll have a client that has a house and a large IRA. So we put the house in the trust, but it's better for IRAs to be inherited by individuals versus trusts, because when a trust inherits an IRA, it has to be paid out at a higher rate and then taxed at a higher rate. Whereas if you leave it to an individual, the payments can be drawn out a lot longer. So I'll usually tell a client, okay, we're gonna put your house in the trust and your investment account in the trust, and your life insurance policy, we can name the trust as a beneficiary, but I'm gonna have your IRA go to beneficiaries. Also, checking and savings, we usually name those to beneficiaries because banks will usually make you, if you want to have a trust account for checking and savings, they'll usually make you close your current trust account and savings account and open a new account in the name of your trust. And I have to do that because I have my little kids, so I can't name them as beneficiary on my checking and savings. But it's a huge pain in the butt. You have to change all your auto pays, all your direct deposits, you know, your mortgage, your income. It's so annoying. So if you're holding a low balance in your checking and savings and you've got adult kids or adult beneficiaries, I usually say don't go through the headache, just name them as beneficiaries on your checking and savings. But sometimes it does make sense to do it.
One thing I don't understand is, though, if there are vehicles like, well, you mentioned the IRA, which I totally agree with, but if there are vehicles like life insurance, for example, which can be direct beneficiaries, what would be the advantage to putting it in a trust versus just the direct beneficiary who does not have to deal with all of that?
So the question is, what's the benefit of making a trust a beneficiary of a life insurance policy versus just naming a person as a beneficiary? So if you, let's say in your trust you have many beneficiaries and they all get different percents, and the life insurance company doesn't allow you to name all those people as beneficiaries, that would be a reason to have it go through your trust. Or I have clients that might have a disabled child, and so they want half of the life insurance to go to their kid's supplemental needs trust and half to go to their kid, so you might name a trust as a beneficiary there. The other reason is if you're a married couple and you've got doing estate tax planning, you wanna capture as many assets as you can in the trust to have get the estate tax benefits, so that would be another reason to pass the life insurance through the trust. If none of those apply to you, then yes, you could just leave it to a named beneficiary.
Where's the threshold in terms of the revocable trust, the spouse beneficiary? Like, in other words, is there a financial limit, like you said, $2 million or something, that when you reach that, if you're over that, there's no benefit at that point
There's still,
to add anything else into the trust?
the goal would be to put all assets even over 2 million in the trust too, because then you get the estate tax savings on that full first 2 million, so it reduce the tax. Yes, maybe some more taxes are due if you've got, several million, but at least you've done what you could to reduce what's gonna be due.
I don't know how to ask this, but if you have durable power of attorney and you die, does the person who has that power of attorney still have the ability to use your bank accounts or credit card?
That's a very good question. The question is, if there's a durable power of attorney and the person passes away, can the power of attorney still access their bank account? And the answer is no. The power of attorney dies with the person. Now, if the power of attorney was your child, and your child was also a beneficiary on that account, then they could access it that way. But if the power of attorney is not named as a joint owner or beneficiary on that account, then they will not have access to it unless they're also either if it was a trust account, then if they're the trust, then the trustee can have access to it. Or if it needs to go through probate, then the person who is named as your personal representative in your will eventually have access to it once once they've been appointed by the court.
Is there any difference between payable on death and beneficiary?
The question is there any difference between payable on death and beneficiary? No, there's no difference. It's really, every bank has their own rules that are not consistent and sometimes don't make any sense. So some banks may say pay on death beneficiary, some banks may say beneficiary, some banks may say in trust for. It all is the same. Means the same thing. Alright, so I'm gonna move on to irrevocable trust. So there are a couple different main kinds of irrevocable trusts. One is called an ILIT, irrevocable life insurance trust. That trust can take, so the value of a life insurance policy can sometimes be quite sizable and then will add to your taxable estate. So you can actually remove it from your estate by doing an ILIT. And then the other one that I think most of you will be interested in is an irrevocable trust to protect your assets from mass health. So a properly drafted irrevocable trust can protect a piece of real estate from a mass health lien or estate recovery, and you can also protect financial resources in there as well. Irrevocable trusts are not for everyone. You need to make sure that the value of your home is not part of your retirement plan, because when you set up the irrevocable trust, you cannot, like I said, with the revocable trust, you have full control over the property. You're in charge in every way. With a properly drafted irrevocable trust for mass health planning purposes, you're not going to be the trustee of your trust, and you're not going to be the beneficiary of the trust. It's effectively a gift to your beneficiaries. We do sometimes have the elder be an income beneficiary. So if your house is in the irrevocable trust and it's being rented out, then you could get the rental income. But you can't have access to the principal, so like the bulk of the asset. If you're doing this for mass health planning purposes, mass health, there's the 5-year look back period again. So you need to fund this trust more than 5 years before needing nursing home placement. Sometimes people will put financial accounts in there as well, but again, it needs to be money that you don't need. You're gonna have no access to these funds. So I always take a look when a client is asking me about doing an irrevocable trust, I look at their house. Is there a mortgage still on the house? Because if there's a mortgage still on the house, you can't do it. I look at their financial resources. Are they gonna have enough money to private pay for their care if, let's say, they set up the trust and a year later they have a stroke and they need nursing home placement? Do they have enough cash to make it through the 5-year look back period? If they don't, then the irrevocable trust may not be a good idea for them. Because what if you wanna sell your home and move to assisted living or downsize? A trustee can sell your home and purchase you a new home, like a downsized home, and still own the trust. It won't, owned by the trust, it won't restart the 5-year clock. But let's say you wanna sell your home and move to assisted living. The trust won't be able to pay your rent. So you need to have enough funds outside of the house to fund your retirement. So it can be a great tool, but it's just not for everybody. Any questions on that? Okay. So we kind of already talked about this, characteristics of a successful fiduciary. So when you're thinking about who you're picking to make decisions for you, you want to think, are they responsible, are they trustworthy? You may have someone in your life that's terrible with money, but they're really great in a crisis. So maybe they're a good healthcare agent for you, but you want to name someone else that's different for the power of attorney. When doing that, when naming different people, you also need to think about, are they going to be able to work together well? Because that can cause a lot of conflict if the healthcare agent is in disagreement with the power of attorney. So that's something to consider too. And then I kinda already covered our attorney fiduciary program for solo agers, where we can serve as power of attorney, healthcare agent, trustee, personal representative for our clients. That's the end of my presentation. I'm happy to take more questions, and thank you so much for having me.
Thank you.
What would be your charge for some of these services?
What would be my charge? So, a consultation is a $400 fee, that's my hourly rate. A lot of the work we do though is flat fee, so it's gonna range in price depending on the complexity of the estate plan. If you're doing a basic estate plan with just a will, power of attorney, healthcare proxy, all those docs, it could be like a couple thousand. But then if you're adding trusts or more than one trust, you know, it increases in price as it gets more complex. So I can't I'm not gonna list off my whole fee schedule for you, but it ranges in price depending on the complexity. Yeah.
Going back to the healthcare proxy, is there such a thing as a joint people? In other words, if you had
Oh,
three
that-
kids and you want, rather than forcing it on one person, that they have to come to a 2-to-1 decision?
That's a very good question, and thank you for mentioning it. So the question is, can you have joint healthcare agents? That also reminds me that I wanna talk about naming joint powers of attorney too. A lot of people will try to name a joint power of attorney, and their attorney may not warn them that that can cause a big problem at the bank. So the whole point of naming a power of attorney is to make dealing with a crisis a lot easier by being able to freely manage assets, but a lot of banks will reject joint powers of attorney. So that can cause a big problem. Joint healthcare proxies, yes, you can theoretically have a joint healthcare agent, but we usually try to shy everyone away from having joint agents, just because if there's arguments between the two of them. So we usually have a primary and then the alternates, as opposed to joint. That's not to say you can't, but in practice, it's usually better to do that. And also, if let's say your primary person is like, I am so overwhelmed by this, I can't do it. They're not required to do it. They can choose to step down and let the alternate take over. There's just a little form we draw up for them to withdraw, step down and have the next person take over. It's pretty quick. Did I see, do you have a question? Or, Bill?
What about on a checking account, joint ownership? So you have two, instead of having a beneficiary, you have two co-owners.
Yeah, so if you have a co-owner on a bank account and one of them dies, the money belongs to the joint owner. So that sometimes people don't think about that when they have several kids, let's say. The kid that's helping manage their affairs is named as a joint owner on mom's checking account, because that makes sense. She's helping pay bills and all this stuff, but then when the mom dies, she doesn't have to give the money to her siblings, and that can cause some problems. A lot of people are surprised by that sometimes. So that's just something to keep in mind when you're naming a joint owner. The other thing that I think is worth mentioning is a lot of people try to get around doing an irrevocable trust by adding their kids onto their deed, or doing a life estate deed. The problem with that can be is sometimes it works fine if you've done it before the 5-year, beyond the 5-year look back period. However, if that child or person that you've added to your deed gets sued, gets divorced, then you've put your house at risk. It's better to do the irrevoke, doing the life estate deed is very attractive because it's really cheap to do it. But if you lose your house in the process because they got divorced, I don't think it was worth it. So doing an irrevocable trust is a much more secure way to get that property eventually to your child or loved one.
Can you talk a little bit about how Mass Health takes over what Medicare is paying, if they do, or where Mass Health comes into the picture?
Sure, I mean, that is a whole other presentation I could come back and do.
So,
Um,
and I'm a Shine counselor, we are gonna talk about, we are gonna have a healthcare day, so
Okay.
certainly come back for that and bring those questions.
And I'm happy to come back, cause I have a whole Mass Health Common Mistakes presentation that I could do, that I wanna do everywhere I can, cause I can help people avoid very common errors.
If total assets are less than $2 million, is there any advantage to having a revocable trust?
Yes, just for the avoidance of probate, it's very helpful to have a revocable trust, even if your estate's under 2 million, for sure.
Oh, I'm sorry.
Yes, you,
No, you just said having a revocable trust is a way to avoid probate.
yes.
Yeah.
Okay.
Thank you.
Anybody else? Yep.
When you're talking about assets in individual names, are there things that slip under the radar? I mean, I was surprised that, you know, a few years ago, when you have two cars, one of the cars may be in somebody else's, the spouse's name. And you don't even think of those things when you
Yeah,
put
so-
them together.
There isn't a whole lot you can do with a car, in terms of probate, because it's not a good idea to put a car in a trust, because it will get taxed at a very high rate. But if your only remaining probate asset is just a car, it's usually very easy to deal with. There was an issue that came up recently in the news, which I've procrastinated on this one for myself as well, but with married couples, it's a good idea for both spouses to be joint owners on the cars, because there was a situation with this woman who, her husband passed away, his name was on the car. It's easy enough through the registry to transfer to the surviving spouse, but there was still a car loan on the car, and the only way they would let her do it was to pay off the full car loan, and she didn't have the money to do that. So, I mean, it's not necessarily a big deal for everybody, but it was a big deal for her. So, and like I said, I haven't done this for myself yet, and I don't know when I'm gonna get to it, but, that's something I learned recently. But if the car is the only probate asset, it's, of all the painful things you need to do with probate, it's one of the lesser painful ones.
Are there other things like that? I mean, I'm just
Yeah.
thinking of things like, you know, joint credit cards, and find out that there's people who, you know, it comes out in a primary name, even though both people can use the card, they don't have access to the finances behind it, it gets really involved.
I know, credit card, I feel like wouldn't be that big of a deal, cause
No.
it's easy enough to get another credit card.
Yep.
I'd say
Okay.
cars are the main thing, and then,
Okay.
or forgotten accounts, I mean, that happens all the time, that people like, even my husband had he worked at one company for a short period of time and had a 401k with them that had like $2,000 in it, and it was just out there floating in no man's land forever because he forgot to roll it over until I bugged him incessantly about it. But that happens a lot, where you think you've got everything lined up, but there's some random little account you forgot about. That can happen.
Thank you.
What about other things like furniture and things, that you might, TV sets and things in your house? That's not in the trust, then.
Right,
That
so,
just has to go to probate, right?
not necessarily, so the question is, what about TVs, books, furniture, etc.? So, one, your attorney should give you what's called a tangible personal property memorandum with your estate plan documents, and it references your will and maybe your trust, and it's like a bunch of blank lines, and you can fill in those tangible items, then who you want it to go to, and then you sign and date it. Usually those items don't have to go through probate unless maybe you have something of extreme value, like a Van Gogh or something, like something of extreme value, then maybe, it might need to go through probate, cause you probably have it insured and all this stuff.
Then just call it personal property.
And then what you'll have, if you're getting a trust, then one of the documents your attorney should draw up for you is called an assignment of personal property. And that document will assign all of your personal property to your trust, so none of it has to go through probate.
How can you find out the date when your estate tax begins. Like, my house became my house very late in my life.
Mm-hmm.
And so will it be taxed, I'd like to know if it would be taxed from the time, I first bought it in, as a couple, or is it gonna be taxed from the time I became the owner?
I think it will be for estate tax, I think it's the date of death value.
But does it, oh, it's the date of death value,
Mhm.
okay, but what if you sell it, what if you have to go to an assisted living? And
So I
it
think
gets sold?
that's capital gains taxes you're
Okay.
concerned with.
Okay, but that matters too, doesn't it, you know, in
Mhm.
terms of how much you have to pay?
Yeah, I'm not an accountant.
Okay,
but-
so that's an
Barbara.
accounting question.
Barbara, we will have a financial planner here on May 22nd, so you won't want to miss that.
Okay, thank you.
But generally speaking, in the just knowing enough to be dangerous category, if, let's say you bought your home in the 70s and now and you bought it for 20 grand and now it's worth $1 million, which is not that uncommon right now, then there are gonna be there's like a $250K capital gains tax exclusion, but I mean, if your home has increased in insane value, then yeah, you're probably, if you're planning to sell the home while you're alive, then yes, you're gonna probably have to pay some big taxes when you sell it. Now, if you bought it a few years ago, the growth in the value is not gonna be as significant, so it just depends. So sometimes with adult children, when we're talking about, do we sell mom's house, and do something else with the funds, or do we keep it and we take a look at, is it one of those situations where it's become incredibly valued? We might see, it might be beneficial to hang on to that property, and rent it out or whatever. Sometimes that's doable, sometimes it's not. And then wait until the parent passes away before they sell the house, because then you get a step up in cost basis to the date of death value of the home, and then significantly less taxes will be due.
Yeah, the name, you said tangible something on the personal property?
Tangible personal property memorandum.
Okay. Thank you.
Mhm.
Did you say something about offering services as a consultant or something like that?
Yes, I offer services as a consultant under our Aging Pathfinder.
Do you typically get through what you need to get through with someone in the hour? You said it's $400 for an hour. Is that typically enough time for a relatively straightforward estate?
The question is, can I get through what we need to get through in the hour consultation? So, it depends. I try to be very efficient with my meetings, and we ask, like, if you call to set up a consult, my admin will send you a questionnaire that you'd fill out with and this is typical of any elder law firm, I would say. Some attorneys might wanna do like get to know you sort of chat. I'm more like, let's get down to business. The questionnaire would get sent out ahead of time. We'd ask you to provide personal and financial information, ask you if you have an existing estate plan, we want copies of that ahead of time, and then I would try to review as much as I can before the meeting, so I can go in with, here's the plan that I suggest and here's why. And then from there, if you choose to hire to do an estate plan, for instance, then you'd sign a fee agreement and you can pay either half up front and half at signing, or all up front. Some people have preferences. You'd have a second meeting, we'd send out the draft documents for you to review. We expect you to review them and have questions ready. We'll have a draft review meeting. So we go through all your questions. If you need something changed, we change it. Once you're comfortable with the documents, then you come back a third time. And some of this can be on Zoom, and it doesn't have to all be in person, but the signing appointment needs to be in person. So there'd be at minimum 3 meetings. But estate planning's flat fee, so you might pay for that $400 consult, but that $400 will be deducted from the overall estate planning cost. And so the 3 meetings don't cost any extra.
So
It's
you
just
said
part.
it's a flat fee?
Mhm.
How much is that fee?
I said that it was, you know, if you're doing a very simple estate plan, it could be a couple thousand-ish, but then if you're doing a trust, if you're doing more than one trust, it increases in fee as the complexity increases. Okay,
Thank you so much.
thank you so much for having me. This is awesome.
Just wanted to say that you're welcome to stick around and chat. We've got a lot of refreshments here still to go, so if you're interested in doing that, feel free.
Oh, great.
Stick
And
around any.
so if you want to join us next week, you can either send us an email or stop by and just see Christina. She has your list and she can check you off for next week. You won't want to miss it. I'm actually presenting. I'm going to be getting into the nitty-gritty of cost. I'm also going to be giving you some planning documents to get you started. Thank you so much, Samantha, for coming. I know I have some homework. I don't know about you guys, but I wrote down my homework. And I hope the takeaway is that regardless of how big your estate is, whether you have $1 million or $1,000, it's never too late or too early to just put the plan in action. You know, you will spend some money up front, but like everybody knows, what is that cliche sort of, you don't want to save a penny and spend a
I
dime.
always say you gotta spend money to save
You gotta
money.
spend money to save money sometimes, yes. And the aggravation of your family. Cohesiveness is worth $1 million.
I would say so.
So, thank you all for joining us.